Okay, so hello everyone. Welcome to the Critical Legal Talks. I'm Alexis Alvarez Nakagawa, lecturer in law at QMUL and host of the series, which are co-organized by the Law Department and the Institute for the Humanities and Social Sciences at QMUL University of London, and the Group of Critical Studies in Politics, Law and Society, or PODES in Spanish, at the University of Buenos Aires. We are thrilled to have Professor Samuel Moyn with us today. Professor Moyn is a Chancellor Kent Professor of Law and History at Yale University. As you probably know, his work has focused on international law, human rights, the law of war, and legal thought in both historical and current perspectives. He has written several books in his fields of interest, including The Last Utopia, Human Rights in History, published in 2010, and most recently, Not Enough, Human Rights in an Unequal World, published in 2018, and Humane, How the United States Abandoned Peace and Reinvented War, which was out in 2021. In today's lecture, Professor Moyn will present a paper entitled Reconstructing Critical Legal Studies. And after that, we will open the floor for questions from all of you. So let me just say before kicking this off that the seminar will be recorded and will be posted online at QMUL's and PODES's web pages after the event. Professor Moyn, thank you so much for joining us today. It's really a pleasure to have you here presenting your paper, and I'm very looking forward to your presentation.
Well, thanks to you for the invitation and to everyone for coming. It's the end of our academic year here in the United States, so I just decided to chat about my paper informally for a few minutes and try to summarize it. And it's really intended as a discussion or conversation starter. So I'm hoping to just have a conversation with you, especially because this paper really does come from an American perspective. I mean, it's written actually out of a class that I teach called Foundations of American Legal Thought. And that's because we have decided, some of us, to try to introduce law students better to the schools of legal theory that have been hegemonic or at least prominent in US discourse. And that accounts for a lot of the emphases of the paper, not least its attention to the critical legal studies movement. But I'll add that, in my way of thinking, although I'm trained as an intellectual historian of a modern Western Europe, there's a certain world historical importance to the critical legal studies movement for all countries, and especially for Anglophone countries where the CLS movement had global effects in opening a space for left-wing legal thought that, either had never existed or, had been shut down in the Cold War. So the setting for the paper, or let's say the hook, is the appearance of a new legal left. And I associate that development with the 2008 financial crisis. It's not that there weren't aging leftists in the academy, including those who had founded the critical legal studies movement themselves. But when I went to law school in around 1998 through 2001, the left was quiescent. It was the end of history, so-called, and there was very little interest in left-wing legal theory, or frankly, legal theory generally, and that has changed. There is since 2008 a growing movement, especially associated with the law and political economy movement, so-called, of which I'd say I'm a fellow traveler, to reactivate left pedagogy, left intellectualism more generally. And it's in its early years, I would say. The law and political economy movement in particular has a manifesto to its name. It has a blog where a lot of interesting material occurs on a nearly daily basis. There was just an event that the law and political economy movement hosted last night on the problem of juristocracy. But what I wondered, having, learned from some of the older founders of critical legal studies as a law student, I wondered what this new law and political economy stood for. I mean, what exactly is its conceptual framework for thinking about law and political economy? And so that's sort of the point of departure for the paper. I wouldn't have written it had it not seemed a kind of promising moment for a renewal of left-wing legal intellectualism, but also a moment of what I found unclarity about very basic questions. And so what I wanted to do is draw on the traditions of especially American legal thought, as I would narrate them and do in this class I mentioned, to pose some questions to the law and political economy movement and really anyone else. That includes, I should mention, a discernible current of neo-Marxist legal theory, which is, not at all prominent in US debates, but is more prominent than it had been. And in the work that I've done on international law, I've noticed that in other Anglophone jurisdictions and even beyond, there's a very clear emergence of a kind of Marxism or Marxian group of legal intellectuals. And once again, I've been wondering all along, what exactly do those who, kind of like fly the flag of Marxism very proudly, what do they mean by when they invoke words like capitalism? What are their commitments in legal theory? So this paper is, on one level, an attempt to go back and revisit some episodes in the history of critical legal studies, but to me, none of that matters. It's pretty antiquarian or trivial, except to the extent it could bear on this moment now, and as I understand it. So that's what the paper is about. And honestly, the paper doesn't get very far. I'll return to this in conclusion. My hope is that by the end, I've ruled out some options for a left-wing legal theory, and then left a very big and I think contentious space for thinking about what remains or how to further develop a left-wing legal theory in the coming years. My hope is that we're at the beginning of such a period when not only do we still need such a persuasive theory, but there will be a lot of takers out in the law schools and the world generally. I think there's reasons to think that's so because of the, attention that the law and political economy movement has gotten, including in England, where I was invited when I was in Oxford a couple of years ago to present it. I know there are chapters, not just in Oxford, but at one or two other British law schools. I'm not sure about Queen Mary. And I think it just in virtue of the hegemonic status of the United States in the world, what goes on, matters to a lot of audiences. Okay, so there are a few different parts of the paper after the introduction where I try to kind of set the stage in the way I've just done. I will say I was also triggered in formulating my strategy in the paper by what I thought were some very basic misunderstandings of the critical legal studies movement in discussions I heard in the law and political economy movement about what kind of legal theory to have. And usually in those discussions, as well as in ones with Marxist friends that I would, raise the topic with, you'd hear very dismissive accounts of critical legal studies. The general view seemed to be that it had been a mistake or it had erred badly. I do agree that it failed in some sense or was beaten, certainly institutionally. But the reason typically cited by friends in LP or Marxist friends for the why CLS should be abandoned is that it stood for something called legal indeterminacy. And I thought this was wrong based on my understanding of what mattered about the critical legal studies movement. And so really, most of all, the paper has the goal of reviving what I take to be the credible or plausible aspects of the critical legal studies movement, which, among other things, requires getting at how the proponents of CLS disagreed with one another. And really, if you take anything away from the paper, is that it ought to be that CLS is not an it was a they, and it was contentious in its time, and it laid out kind of like options that we have to consider, sometimes to reject, but it's not as if we're the first ones to, take up these very basic concerns. Okay, so I'm going to be very brief about the first main section of the paper, which is about what kind of legal theory we should want generally. And this, I hope, applies across the board politically, but it certainly should apply to left-wing legal theory. And what I argue there is that there has been a tradition of trying to build a social theory of the law. It starts out, I suppose, with Montesquieu, and certainly runs through Marx, but through lots of non-Marxists like Durkheim and Weber. And I argue that CLS was one of the last major attempts to innovate in this tradition. I don't want to get into detail about what this tradition stood for. I think it's a strong counterpoint to prevalent approaches to legal theory, which have tended to be normative in character, which have tended to try to discover, let's say, the nature of right and wrong, often with, let's call them, moral realist commitments, and then try to bring law into whatever desirable conformity there ought to be between morality and law. And this has been especially powerful among liberals and really in circles in legal theory affected by the hegemony, not of any American institution, but of the University of Oxford after the debates that Hart and so forth catalyzed. I argue that CLS really can't be understood as an entrant in the normative theory of the law. Rather, it was an attempt, and we ought to follow it to exhume a social theory of the law that understands law in against the background of social relations, and that could include institutions, or if you have a theory of social relations that's a Marxist one of capitalism, then that's what you do. I have a bit to say about the cultural turn within social theory, just because it should really matter to us as legal theorists to engage what's been said by our colleagues about the cultural study of law because law is also interpretive. It's about meaning and meaning making. And as much as it's about authority, it's about interpreting legal provision. And that ends up being pretty central to the paper. But I won't say much about that first, let's say, you know, a preliminary part of the paper on the tradition of social theory that CLS joined. I actually think when we look at the intellectual history of American legal thought, there may have been some innovations, but in CLS, but there was a lot of inheritance from the tradition of social theory too, and I think it's worth recovering those. So that then brings me to the main part of the paper, which is against that backdrop, an investigation of some particular debates in the history of critical legal studies, again, on the premise that they matter now. And basically what I try to show is that the main three founders of CLS, as I understand it, at Harvard Law School in the 1970s, that would be Morton Horowitz, Duncan Kennedy, and Roberto Unger, were as much arguing with one another about these very basic questions of a credible social theory of law. And what I try to show is that those disagreements remain unresolved. And I take sides, but my main point is that everyone has to take sides. And if that's true, then you can't just dismiss CLS. You could only dismiss mistakes that others within CLS tried to resist. Now, that's not totally fair, because I'm sure there are a lot of options that no one in the critical legal studies movement ever, outline. But to a remarkable extent, I would argue that most of what we need to still be talking about was already in the debate among the principles of CLS in the 1970s and 80s. And that debate may have stalled or died down and the movement was destroyed or failed or whatever. But we're intellectually, we're not, we have not transcended their situation. Now, one could argue actually that they were just a kind of the latest stage in a very long enduring modern situation where, since the days of the German idealists and Hegel and Marx, we've been in a very unresolved situation about how to think about social order and its evolution and the law's relation to it. And I would agree with that. I just think that in legal academia, in the recent period, CLS to me is so valuable because it reiterated these basically, perennial debates. So what were those debates? I focus on two. The first one I'm going to talk about in terms of functionalism, which is the idea that a credible social theory of law places center stage the social functions that law generally plays. And I start with Horowitz because, though he wasn't a Marxist, I think in his classic book, The Transformation of American Law in 1977, he came very close to what we could call a vulgar Marxist account of law and society. It's a brilliant book that he wrote, in part because it's so simple-minded. What he argues basically is that as capitalism, emerged in its classic form in the 19th century, jurists made two moves. First, they refashioned inherited law in the service of capitalist norms. And then in a second move, they disguised their work by saying that the law is a gapless system of rules and legal decision makers merely apply those rules mechanically. In other words, they invented what we call formalism, legal formalism, as a kind of justificatory ideology for the work that jurists themselves had done in making law serve the new capitalist social relations that emerged. And this was an argument that was exceptionally powerful, I think had an enormous impact on American and really transatlantic legal thought generally, in part because Horwitz at that stage in his career was so open to a kind of vulgar functionalism. His basic idea is that law serves power and wealth. And as those change, law changes because the jurists are the agents or made the agents of those powerful social forces. And the second move I mentioned is really interesting because implicitly it's a theory of ideology, that law doesn't just serve as a functional tool, but it also has a role in mystifying or rationalizing some of the work that law has done in the service of power and wealth. Now, as I try to show, Duncan Kennedy and especially some of his disciples were turned off by this vulgar functionalism. And I try to dramatize this not just by looking at Kennedy's own version of the same history in a long unpublished manuscript that everyone read at the time, but primarily by looking at the really quite influential article by one of Kennedy's disciples named Robert Gordon that basically argued that the law is functionally underdeterminate to the point of being indeterminate. Now, what was this about? So in the 1970s, among Marxists, there was a big argument about whether to be vulgar. There's new literature actually by Edward Bering, it's cited in the piece, about how the origins of Western Marxism back in the 1920s, Georgy Lukács and so forth, really took shape around the rejection of the vulgar Marxism, so-called of the Second International, Karl Kautsky and so forth. And the 1970s, in the era of Althusser and Poulantzas and so forth, there was a kind of reenactment of this gesture of branding others as vulgar, reductive functionalists and trying to hew out some more sophisticated Marxism. The question is what form it would take. And Duncan Kennedy, though he didn't affiliate then or really rarely ever as being in dialogue with Marxism, I think made a similar move as some others anti-reductionist Marxists have. And basically he said that the law is relatively autonomous from social relations in the very era that Morton Horwitz portrayed law as a kind of instrument and ideology of power and wealth. Kennedy said the law is relatively autonomous from such forces, and that's why lawyers, legal theorists, need to construct the intellectual, including doctrinal world of different places and times. Now, we could get into the history of the phrase relatively autonomous, but it's question begging. And it ends up, I think, in many of the instances in which it's been deployed in the history of thought to really be an argument for freeing legal theory from social theory and treating the law as effectively autonomous, which I think is probably a worse mistake if one had to rank them than the kind of vulgar reductionist Marxism. At any rate, what I try to show is that if not Kennedy, then Gordon in this classic paper, Critical Legal Histories, really says something like the following. Well, law is complicated, and one can always imagine different legal arrangements that would serve the same functional imperatives. And if that's true, then it's never going to be an adequate explanation for some legal outcome or legal regime to say that it served functional ends. And his fancy way of saying this was that law is functionally underdeterminate. And to that extent, we need accounts of law that recognize the contingency of outcomes. They could have been otherwise. Even if one supposes that law generally serves functional ends, that's never an adequate explanation of any particular outcome or regime, because there could have been different outcomes or regimes consistent with the ends. Now, I actually think, Gordon's paper, which spells out this idea in pretty great detail, is really important, and it puts us on guard against excessively reductionist or vulgar accounts of law as an instrument of social purposes, power and wealth from a left perspective. But what I try to show is that in citing Kennedy and leaning into his thought, Gordon, in a sense, excused himself from social theory on the grounds that there's functional underdetermination. And as I see it, that's disastrous. One reason is that Gordon inspired a lot of really the current crop of legal historians in the United States to write a lot of books saying the point of scholarship is to show that some legal arrangements were contingent in their origins. And that's just not very interesting. It's not even true. In many cases, but to the extent it is true, it became very repetitious. And so if one had, in the Soviet Union, a lot of very boring repetition of the claim that law is a bourgeois phenomenon, in the bourgeois United States, for many decades, one's had a very boring scholarship that says the laws we have emerged contingently and could have been otherwise. Now, I think a lot of people made this move apolitically, but a lot of leftists, on my account, leaned into this style of analysis because it was very attractive in a long historical period, namely the period roughly from the 1980s through 2008, when it seemed as if the left had lost. And the most one could do is look back and say, in a kind of mournful spirit, well, that was an accident, or things could have been otherwise. And to the extent, one wanted to kind of hibernate or keep hope alive for some future for progressive law, one could say, well, this accidental outcome in the victory of capitalism or neoliberalism or whatever, could be undone in some future conjuncture when another set of contingencies will allow the left to take the lead. But, even if you don't accept that account that I put in the paper of a kind of generation of leftists that felt beaten and, looked out at the world and in a kind of mournful posture, there's a kind of deeper reason to think that this commitment to functional underdeterminacy for its own sake was disastrous. And that's because it really doesn't solve the problem of how to fit together the fact that we know that law is oppressive and regularly hurts people, and that's not accidental, with the fact that it's true that there's an underdeterminate character to a lot of law functionally. And so what was missed, I think, was the chance to try to reconcile the credible impulse in Horowitz with the credible impulse in Kennedy. And what I try to say very briefly is that Unger tried to do this. And so if he was right about that we need to recognize that law serves structural imperatives, and that it does so with some amount of functional underdeterminacy in the mix, then we just need to figure out how that works. And maybe we need a social theory that's local about different outcomes, but maybe we need a different theory of modernity that, you know, can rise above the local to balance these two kinds of comparisons. And so in a way, I mean, I basically try to say that Unger won, but even if you don't agree, you should accept that there was a debate that, you know, really is about very basic alternatives in how to construct a social theory of law. Okay, so then that big part goes on to a different debate, which is about meaning or semantic meaning in the law, and above all, interpretation of constitutions or statutes or custom, especially but not only by judicial figures. And what I try to show there is that it is somewhat different, that as far as I can tell, CLS does not deserve the reputation it acquired for standing for legal indeterminacy. Now understood as a kind of interpretive theory that says law is indeterminate. You can reach any interpretation of any provision or norm you want. Judges can do so. And what I try to do is illustrate this fact by reviewing the positions of the same three principles, Horwitz, Kennedy, and Unger, and then, you know, trying to show that none of them really embraced a theory of legal indeterminacy in that sense I mentioned, but that they still disagreed, and that we're in a sense, again, in the position of having to decide whose side to take in that dispute, not whether to believe that the law is indeterminate, but, you know, how to think about what determinacy law can have. Okay, so I'll start again with Horwitz. Basically, I claimed that he thought law is pretty determinate. It really mattered that in that first stage in 19th century law, jurists changed the content of the law because it mattered what its content was. The content of the law became more capitalist so that it could, you know, reflect and, you know, advance capitalist social relations. And to the extent in the second move that I said Horwitz made, law is supposed to have some ideological effect in, let's say, rationalizing or mystifying capitalist social relations. I suppose you could say that it would be possible for someone to think that a theory of legal indeterminacy would just be confusing, so it would mask whatever is really going on. But that wasn't Horwitz's view. He thought that the law was pretty determinate, and to the extent that these jurists invented legal formalism, their whole idea was that the law is determinate. And that's what allowed law to play the ideological functions that Horwitz thought it did. So it's kind of crazy to think that CLS could ever be said to involve a theory of legal indeterminacy, because Horwitz's whole approach to the law is that law is determinate. It could only play, let's say, the vulgar functions that his account said it did on condition of law being pretty determinate, you know, maybe with some exceptions, but not many. So then I look at Kennedy, and of course, he's a very difficult case because he says a lot of different things, you know, over a long period of time. And I don't want to attach any views to him, but what I basically try to say in the section about Kennedy in this part of the paper is that he was a structuralist, in the sense that Piaget was a structuralist, or Saussure was a structuralist, or the early Foucault was a structuralist. They were not interested in social relations so much as in structures of thought or discourse. And what Kennedy tried to do in many of his classic exercises was to show that legal consciousness constrains those actors subject to it in the same way that an episteme in Foucault's order of things constrains those, or the langue in Saussure constrains anyone trying to, speak parole in Saussure's account. And that doesn't mean that the structure that you'd find in some account of language or law doesn't leave room for alternatives, but those alternatives are structured, and the rule of structure is constraint, not, indeterminacy. And presumably any credible structuralist theory of language or law is one that doesn't allow you to do whatever you want, including reach any legal outcome you want. It takes some things off the table. It may provide room for maneuver too, but okay. One of Kennedy's, I think, central insights is that law often has a kind of legal decision making often has a structure that is what he thinks of as diremptive. There's a principle and a counter principle, and at most you get to choose from a menu of two things. You can honor a contract, or you can find some escape from honoring it, and that wouldn't just allow you to pick winners, although sometimes it would, but you would be obeying this deeper structure of principle and counter principle. And we could debate in the discussion whether that is enough to motivate the idea that Kennedy was committed to indeterminacy. I don't think that's exactly a useful way of recapturing what he was trying to do. But I do think it's fair to say that he, and again, some of his disciples ended up departing from the project of a social theory of law, let's say, out of their obsession with characterizing legal discourse properly in a structuralist vein. So in the same way, we could argue that Foucault was a disaster for all his brilliance for social theory, because he led generations of people into this kind of structuralist analysis, which of course he abandoned. We could argue that Kennedy plays the same role in legal theory, and what gets lost is, let's say, the basic project, which is figuring out what is the relation of law, which is one thing in the world, to overall social relations in a time and place. And if we're interested in legal meaning, which we have to be, an interpretation of constitution, statutes, custom, whatever, we need a theory that's still a part of that conversation. And for that reason, just as in the earlier part, I turned to Unger, who I think was trying to develop such a theory. So in the later part of his career, Unger rejects indeterminacy as a theory. Doesn't say, because he never used footnotes, who he thinks had that theory. I think he thought Kennedy did. I don't think Kennedy did, but it doesn't matter. The main idea is that Unger says the whole idea that law is indeterminate was kind of symptomatic of a beaten left. And I think, once again, that's just as in the arguments about functional determinacy and underdeterminacy. That's pretty, I think, accurate to the generational experience of people who, saw their revolt in the 1960s fail or be beaten. And in the, academy where they sought refuge, thought that it would be a powerful thing to say that words matter, interpretation is demiurgic and powerful in a way that their practical didn't match their own practical experience as a generation in revolt. But regardless of whether that's true, I think it's very important that Unger tried to put interpretive questions in their place, generally, and then interpretive underdeterminacy in its place. So it's not that law isn't there to be interpreted, and we can't, have a legal theory that omits that law is not given. It's always interpreted by all relevant actors, and there are a lot of ambiguities, conflicts, and gaps in the law that actors resolve and in various ways. But ultimately, law is serving some social functions, for better or worse, and it matters what the law is and who controls it and what they do with it. And it matters less, or not on its own, what interpretive flexibility there is in law generally. And so we could get into more detail in the discussion, but basically I tried to provide a symmetrical account of interpretive determinacy and underdeterminacy, as I do with the debate around functional determinacy and underdeterminacy. The difference is just that I don't think anyone in CLS really held the view that law is whatever judges or other relevant actors want to make it in any given instance. They did disagree about the, let's say, amount or scope of underdeterminacy in the law. And we should have to return to that debate. Now, this really matters. Let me just conclude, because I've been going on maybe too long, when we get back to the present, because what I do in the rest of the paper is review various schools of thought that I don't think have really reckoned with these problems. One is the LPE movement, and I base that claim on the existing materials. And I basically say that the law and political economy movement appears, from what I can tell, to be neo-Horwitzian. Another way to say that is to say that it's a vulgar Marxist or non-Marxist reductionist account of law. There's capitalism and neoliberalism, and law is in its service. Now, obviously, that is partly true, but it's not as simple as that. And that's why the review of the debates around determinacy matter, both on the functional side and the interpretive side. And what that means is that LPE has to have a theory that either returns to some extant option and defends it in CLS, or finds some other option. It hasn't done that yet. In the balance of the paper, I basically look at three other schools. One is legal feminism, one is critical race theory, and one is neo-Marxism. And basically, what I try to show is that everyone's in the same position as the LPE movement. A good example would be Marxists, who are more numerous in the United Kingdom, who seem to me to be saying, in spite of their absolute contempt for the critical legal studies movement in many instances, to have adjusted Marxism so that the last thing it's going to be in our day is a vulgar Marxism. And what that means is, either it's some form of Western Marxism and Lukács's mold with so many different iterations, or it's learned a lot from the critical legal studies movement. And for my money, honestly, no one in Western Marxists thought ever took as seriously as the crits these very basic problems in legal theory proper of the underdeterminacy of law functionally and interpretively. So to that extent, I think any way of rehabilitating Marxism will have to be by way of the critical legal studies movement, correcting some mistakes perhaps, but not just abandoning what it contributed, which was, I think, epoch making. I'll just stop there, because the same basically I want to argue is true of other schools of thought, legal feminism, which I illustrate by reference to Catherine McKinnon, and critical race theory, which I illustrate by reference to Derek Bell. But the reason I can skip those is because, as one of the great aspects of the law and political economy, which movement, which is so different from CLS, is that LP incorporates legal feminism and critical race theory. And its whole theory of domination, rightly, is intersectional in the sense that it incorporates race and gender, among other things, and understands that, intersectional domination is not additive, but, intensified by the intersection of various forms of oppression. And CLS didn't do a good job in that regard, and there's really not much else to say about that fact. And so this is something that is, I think, exciting about the law and political economy movement. But what it doesn't help to say is that those other movements, feminist and critical race movements, have somehow solved all the basic problems in social theory with which the crits struggled. So I think we're all in the position of having to go back to this extent to CLS, think about what it left behind and how to build a radical legal theory now. So I'll stop, and thanks for your indulgence, and look forward to challenges and engagement.
That's great, Sam. Thank you so much for. Well, I have a lot of questions. It is a fascinating paper, and you also add some additional information in the presentation. So we have some time for questions and discussion now. You can write your questions in the chat or raise your hand. So I see that Dimitri has his hand. Dimitri?
Yeah, thanks so much, Alexis, first of all, to you for an amazing series and also for a fantastic talk now. And I think it does us all a great service in canvassing so clearly some of these key themes and questions that underlie CLS, and I got a lot out of it. I just want to kind of push a little bit on the indeterminacy points, right? So, and I guess my kind of key understanding, my kind of key question here is to what extent we actually need the question of indeterminacy to come to a kind of LPE type project. So for me, the idea of indeterminacy is not at all to say that the law is substantively open-ended, that there is flexibility and freedom, etc., but rather that what grants law determinacy, or what shapes the determinacy of legal outcomes, are factors external to law, right? And this is what Marty has famously picked up in the sort of transposition of that idea to international legal theory with this whole notion of the structural bias, which for many Marxists was just like, well, hello, you've discovered capitalist modes of production somewhere there. And so the idea then is that indeterminacy is not freedom, it's not flexibility, it's not substantive open-endedness, but it is a resolution of the tension between law's relative autonomy. So the idea that law is not just a passive conduit for social forces that are always already assembled somewhere else. And on the other hand, the relative stability of distributive effects that the law generates. And so in that sense, I'm not seeing any contradiction between the indeterminacy thesis and the observation that law serves specific class interests. I actually think indeterminacy is the precondition to understand law's heteronomy and to understand what gives stability in the context of structural indeterminacy. And for me, that's what the LPE project is precisely kind of about. So in that sense, I don't think indeterminacy is about semantics or interpretative flexibility or about freedom or etc. It's about trying to understand, it's about trying to get to that space that is delineated by external limits of what constitutes a competent legal argument. And I think that's kind of where the political work begins. And I don't understand how it can begin without that opening of indeterminacy. That was quite long-winded, but yeah, sorry.
Alexis, do I just respond, or?
Yes, please.
Okay. So good to see you, Dimitri, and excellent intervention. So I think I might disagree in three different ways, recognizing that your rendition is pretty standard in certain circles. It's been said in various at various times before. And so it could attain the status of a kind of conventional wisdom. And I think I would resist it for a few reasons. One is just maybe the LP movement can't be said to stand for that view, because it doesn't. I mean, it's just very unclear what it stands for. If it did adopt that view, then it would be different. But I don't think we're even at the point where there's consensus about this. There's not consensus about anything with respect to LP, just because it's a deliberately anti-theoretical movement to date. And that's one of the reasons I wrote the paper. So, that this is really important to me, because like I care much more about like people having positions than there being persuasive to me. And one of my frustrations with LP as a fellow traveler is just like, I'm not sure what it is about. If it were about what you said, then that would be like, there'd be I think a somewhat different set of concerns. Okay, so the second reason I might be a little bit unsure is that I don't think that it is the meaning of indeterminacy that Kennedy is thought to have introduced, at least for a long while. Like, there's some retconning in your account. Now, that may not matter. What may matter is like what we should think now about the indeterminacy of law. And I agree with you that the position you outlined was developed, but that's not how it happened in the beginning. In part, it was in the face of like, others, and a big in the course of a big debate that happened, that the position about the determinacy or indeterminacy of law you outline was reached. I would insist that indeterminacy in the era of inception of this debate was really defined by adversaries of CLS that did succeed in defining it in terms of anything going legally. And maybe that actually helped develop the more complex or sophisticated account you outlined. But I'm just mentioning now as my second reason that we wouldn't want to paper over the historical origins of the very position you're adopting, which involved a lot of different meanings of indeterminacy, or both in CLS and among its enemies. But then we come to the all-important third reason, which I think is the most important, because it's kind of conceptual and theoretical now. And I find it, I don't know, I'm not sure, but it seems odd to me that we would say the law can mean anything, and any stability it would have is let's say an effect of external forces. And that seems like that it just can't be true for a few reasons. One, I think Kennedy did capture that the relative autonomy of law, or whatever you want to call it, means law has some of its own internal constraints that it imposes on, among other things, interpretive practice. And I don't know if we need a structuralist theory of interpretive practice, but it's not as if the law is just, an infinitely flexible thing, quite apart from what powerful forces. For that matter, it seems very odd to say that determinacy in our world is provided by social forces, which, unlike law, which can never be determinate, are generally determinate. So I would want to distribute the underdeterminacy that I've been talking about, not just within law, but in society, which, like, people, I think is pervasively underdeterminate in a lot of ways. Now, that said, I totally agree with you that there's a way in which we need to demote law law's importance, and this was, I think, the great insight of vulgar Marxism or, Horwitz or LPE, that we really do need to return to a form of legal theory that puts law in its place and understands it as part of, some larger social theory. And what that will mean, I think, is that a lot of what law is doing can only be understood by reference to what's outside law. Where I disagree is that we would make a cut and say law is indeterminate and society is determinate. Rather, I think we should say there's underdeterminacy across this divide between law and society, and it's specific, and maybe we can develop a fancier theory of it. So those are my three reasons for resisting your account, which I have heard before, and I think it would be a really powerful position, but it fails, I think, let's say descriptively, to characterize these debates historically to an extent, and it may fail theoretically for the last and most important reasons I mentioned.
Great, thank you.
Let's take another question. Yeah, Panos, please go ahead.
Hi, firstly, I want to thank you for the organization. Yeah, so I hope to state it quickly enough. I hope it's two questions, but I hope it's short, and I think it's related. So the first question is the relation of both CLS and law and political economy to legal realism, because when I first read the manifesto, and I want to say specifically the Yale manifesto, I was intrigued on how I was expecting more references to CLS, and I saw more reference to realism. And then my first impression, so I'm based in Germany, so I'm not there, I don't really know what's going on, but my impression from the papers is that, so if it's, not impression, sorry, my question is if it is like a lawyer's trick, if it's like more than just a philosophical question, if it's about claiming legitimation in what seems to be really important in history of the US legal realism. Yes. And secondly, exactly on the point of your paper and on LPE and how theoreticals or atheoreticals it shall be, I'm feeling that the answer to you is a bit kind of weight, which should not theorize a lot. But the theoretical argument would be like a Polanyian argument saying, we are about to enter this fourth Gilded Age, we are about to enter the New Deal of our times, we should not miss this chance. And then my own position on this second thought is that, yeah, that the argument that a lot of people say that, yeah, is this too US-centric? And then maybe to try to open the discourse, like to theorize selectively or saying how determinate society shall be or not. Because it seems to be an argument of saying for the US that the society is determinate, what you criticized. Yeah, sorry, I think I said enough.
No, thank you. Thanks for those really interesting comments and questions. Now, by Yale Manifesto, you mean the Yale Law Journal article that?
Yeah.
Okay. Okay, great. So yeah, no, I mean, you're totally right that when you look at that, and I say this in the paper, it seems as if the true inspiration for LP theoretically, if one had to choose something, would be legal realism, especially the kind of anti-formalist and let's say, politically progressive elements of legal realism, which was, trying to justify what became the New Deal. And there's much more direct citation of Robert Hale than of Duncan Kennedy, let alone Roberto Unger in the manifesto. And that's totally right. Now, that doesn't mean that that's it, because as I mentioned, it's so important to the authors of the LP manifesto and to people in LP generally to, not just to like help the white male working class a little as occurred in the New Deal. And if you look, you find theories of racial capitalism and patriarchy all over LP discourse. So it's clear that LP is open to subsequent developments in the law. Now, that doesn't mean it is open to CLS and or that it should be. I guess, I would say that if the LP movement is just wants to redo the New Deal, then it's just less interesting to me, both politically and in a way theoretically, because it's just a kind of familiar version of what we would call in the United States left liberalism, and I think whatever else was true of the crits, they dream bigger. And that's because they were in revolt against precisely the success of the, whatever you want to call it, the Wirtschaftswunder or the Trente Glorieuses or whatever. That's when people in the 1960s who were countercultural and wanted to revolutionize everyday life and not just get a little bit more distributive justice appeared. Now, the New Deal would be great if, to the extent our main concern is, something called neoliberalism that is basically about class inequality and our goals are moderating it. Well, then, of course, the New Deal or something, whatever else, other forms of it internationally matter. I think, I'm with you that this movement is pretty parochial as of now. I think that's ironic because the founders are Amy Kapczynski, who trained to work on international intellectual property law, and David Graywall, who trained to work on international trade law. So it's kind of strange that LP in practice has been so parochial, not just in like the organization, but in its US focus. I think there's, in fairness, an attempt to correct that. But I mean, basically, I'm not sure if this is responsive, but I wrote this paper because I ultimately think that whatever else people in law schools are doing, they should care about their theoretical framework. And maybe there's an argument to make that legal realism is just sufficient, maybe with some tweaks to take account of, patriarchy and racialization. And I would want to doubt that, although I think legal realism made, a much bigger contribution on balance than CLS, because there was only one part of legal realism that was really committed to a social theory. And as you know, probably devolved very quickly into a pretty, unacceptable form of social science. So CLS to me is much more exciting as an attempt to develop a big social theory and dialogue with classical social theory like Weber and so forth. And that's what I would like to see. So that makes me comparatively much more interested in what at least members of CLS were trying to do. It's worth mentioning that CLS was much closer to Marxism than legal realism. And so there too, I think if you're really wanting to push legal thought, CLS has pushed it furthest, both politically and intellectually. And so maybe LP should care more about what it was trying to do.
Thank you.
Any other question? I can maybe ask a question in the meantime. So my question is more of a clarification about a kind of tension I see in your paper.
Okay.
So one of the main arguments of your essay is the defense of a social theory backing functional determinacy to explain, law's current determinations, futures, or how the law works, to say it, plainly.
Yes.
You make, as you said today, you make the point that the law is not autonomous. It's not completely autonomous. So to do this, you speak of the social order and the social or social relations as a kind of determining causal factor that gives law form, meaning, or purpose. But in my impression, you are never very explicit about what this social order or social relations mean, right? That is,
yeah, okay.
you leave these categories a little bit under-theorized, to use your phrase. But it seems to me clear that these are like a totalizing or total categories which aim to encompass different orders of life, of human life, in one ordering or organizing category. So in this regard, law for you, and this is my interpretation, will be just one element in this social order, which I assume encompasses other elements such as the economy, the state, civil society, and so on and so forth. But I was wondering if this way of looking at things, or I believe that this way of looking at things seems to be at odds in a way with your theorization of capitalism at the very end of your essay.
Yes.
When you criticize Marxism for conceiving capitalism as a kind of one monolithic thing, or in a too abstract way, when it should be better understood, you say, as a kind of ramshackle construction characterized by different forms of institutions and practices and so on. To the point that you also claim that we could conclude, that there is not such a thing as capitalism, right? This is what you say at the end of your paper. So you are aware of the tension, I think, in the paper. That's why you make this clarification immediately, by saying that this claim about capitalism doesn't necessarily mean that it doesn't exist such a thing as a kind of institutionalization of social order, right? So you go back to your first argument. But then my question is, this social order category that you use throughout the paper seems to me to be more abstract and general than the notion of capitalism that Marxists employ. So is this not abstraction at odds with your critique of Marxism? Is it not also an indication of under-theorization in a way? Because you are mainly replacing the notion of capitalism by this notion of social order, which is quite abstract and quite under-theorized. So my question would be, could you be a little more specific about what you mean by social order and social relations? And I want to make also a quick disclaimer here. I don't want to be unfair, because I'm aware that lots of the literature and lots of the scholarship use the term social order or social relations without giving it a kind of substance to these categories. But in your case, this question seems to be pertinent because you are precisely criticizing Marxism because of their abstraction, and you are also criticizing the LPE scholars for their kind of under-theorizing stand. So could you maybe develop a little bit more about these categories that you use?
Okay, so thank you for pushing me. That's really interesting and helpful. I would say that, I want to avoid the force of the criticism. Let me try, but, keep pushing me if I don't adequately escape. So it is totally right that this is a preliminary argument. In the end, what I've ruled out are like pretty implausible extreme claims to forms of social theory that are excessively vulgar and forms of theory that are not part of social theory, even when they start out trying to make social theory more complex, as some of the crits did, and end up giving up the project. But that leaves a huge range of possibilities. And so by my own account, there's tons of specificity to be placed in some more successful theory. And you're totally right about that. I think we're having a kind of dispute then about whether social theory should have holist commitments, or should place the concept of what many Western Marxists called totality central to its agenda. And the idea would basically be this, that if you think so, what you're mainly interested in is the forms of life and thought that some set of social arrangements make possible, that exclude a lot of others. And, providing a theory of that, order, which is exclusionary, including of a lot of ways we might want to live together or think that aren't available. And that would be true no matter how much complication or inward differentiation, a social order could have. It would be one thing rather than something else. And as you said, I mean, though there's lots of underdeterminacy, not just in the law, there's going to be some relation between the social order and its economy and its arts and it's the intimacy interpersonally that is available to us under it, and so forth and so on. And that's the project. You're absolutely right about that. What I then can't criticize Marxism for being is holist, but I think I follow Unger in some skepticism about whether Marxism is a successful holism when it comes to its account of modern political economy. Because it seems as if what we've learned, and largely thanks to legal thought, especially legal realism, given what we understand about the nature of contracts or the nature of property rights, is that we really can't think of political economy as, in the way that Marx did, especially if we do take seriously the parts of capital that, characterize it, not just in capitalism, not just in terms of the extraction of surplus value, but in terms of the systemic dynamics over time that Marx thought about. And, with respect to Marxism, I assume it's very consistent to be able to say, well, look, there's just too much inward differentiation in the range of market orders we not only could have, but do have and have had, to allow this concept of capitalism to do much useful work, without abandoning the idea that there could be some other theory of social order. I agree with you that to the extent one celebrates differentiation, one puts under threat the whole idea of social theory, that there's structure. But I don't want to take it that far. I don't think it's makes sense to take it that far. So it's an intricate balancing act then to deploy some of the thought about differentiation and underdeterminacy to make, to place a lot of pressure on historic forms of Marxism on the one hand, while not just, abandoning social theory and the quest for some other credible structural account. And that's why I just, spend the first part of the paper saying Marxism isn't the only social theory. And there have been a lot of different attempts to say, we live in, organic solidarity today, or we live in disenchanted bureaucratic forms. And, these are very powerful views, even if you think Marx, if you had to choose one, Marx had the better of those arguments. So what appeals to me, I can't defend it completely in this response about social theory, is that it's not giving up the main prize, which is a theory like that, which isn't to say that Marxism as we know it is it yet.
Great. Thank you, Samuel. Do we have any other question? Okay. Well, if we don't have any more questions, I think that we can wrap up here. Thank you again so much, Samuel, for joining us. It is a great paper. I really enjoy reading it. I also enjoy all the additional details that you put to the paper in this presentation. So thank you so much. Thank you also to the members of the group of critical studies in Buenos Aires for joining us. Thank you, Gulsh Khatun from the QM events team for your support as always. And thank you all for joining us. So we are going to continue with the series probably next academic year from September or October onwards. So please stay tuned. And okay, so bye now, everyone, and thank you so much for joining us.